Mr. Atish Majumdar, a civil lawyer and a consultant medical legal counsel. The stage is all yours, Mr. Majumdar.
Good morning, everyone, whosoever are here. In my more or less more than 2 decades of this profession, now this Dr. Pradhan is there. Medico-legal conferences have not yielded much crowd, unless there has really been something which has put the person concerned into some real jeopardy. So, my CIPLA friends were telling me, with whom I have been doing this for the last 7-8 years, that we are in the process of getting the doctors up here. So I assured them, don't worry, they will gradually come one by one. Let us start. Dr. Pradhan probably doesn't know me personally. 25 years back, my father, who was also a medical practitioner, was operated by you in TURP prostate at EDF. So, just after reaching here, I could see, in fact, while I was coming down, I was recollecting your face 20 years back. So, here I could identify you. Now, coming down to my very subject itself, medico-legal, in my opinion or in my experience for the last so many years, is no specific discipline. There has been a term going around, medico-legal. Actually speaking, there is probably no term or terminology as medical discipline or medico-legal discipline in our subject, that is study of law. Medico-legal has basically evolved from the circumstances arising out of the law of tort. The law of tort is a common law which is prevalent in England for years together by now, if not for more than 100 years. So whenever there is an act of damage caused to any individual, the law of tort comes into play. A law of tort theke, from within this law of tort, came up this Statute of Consumer Protection Act, which primarily deals with the subject of compensation, deficiency of service and other things. So, as I begin with, trying to keep it as short as possible, over the last 2.5 years, bearing the pandemic, there has been one more thing that has been coming up, that is the Consumer Protection Act 2019. Now, whosoever has been working in this field has probably heard this little much, that there was an act called Consumer Protection Act 1986. Now, that particular act has been repealed altogether, deleted altogether. And the new act, which is the Consumer Protection Act 2019, has come into play. In the first 1.5 years, I have been facing quite a few questions from medical practitioners who have been my clients from institutions whereby I am retained, that are we really included? Are we still there? Is our service still within the purview of this act? So obviously there is no consolidation of opinion at that point of time that as to whether it has really been included or not, which has ultimately taken as much time as 2022, 7 to 10 days back. At least I have something to tell the conference here, that yes, it is included. How come? There has been a recent judgment before the Honorable Supreme Court some 10 days back, probably 29th of April. And in that judgment, the Honorable Supreme Court has basically affirmed the judgment passed by Bombay High Court. Bombay High Courter একটা জাজমেন্ট হয়েছে, জাজমেন্ট আমি গাড়িতে আস্তে আস্তে পড়ছিলাম। ইটস এ 3 জাজেস জাজমেন্ট, 3জন জজ সাহেব ছিলেন আমাদের ওয়েস্ট বেঙ্গল থেকে। ওদের চিফ জাস্টিস এখন আমাদের ভেরি ওয়েল নোন অ্যান্ড ক্লোজ টু আস জাস্টিস দীপঙ্কর দত্ত। লকডাউনের সময় যিনি নিজে গাড়ি চালিয়ে এখান থেকে বম্বে গিয়ে জয়েন করেছিলেন, দ্য হোল রোড, একটু অন্যরকম মানুষ। অ্যান্ড 2 more জাজেস এই জাজমেন্টে ইনক্লুড করেছে সার্ভিসকে এবং বলেছে যে অ্যাজ অফ নাও, অরিজিনালি পুরনো একটা জাজমেন্ট ছিল, আপনারা কেউ কেউ হয়তো কখনো কখনো শুনেছেন, ভিপি সান্থা বলে একটা কেস ছিল অনেক আগে। এই ভিপি সান্থার কেস অ্যাকচুয়ালি এই সার্ভিসকে ইনক্লুড করেছিল, মেডিকেল সার্ভিসকে, উইদিন দি পারভিউ অফ কনজিউমার প্রোটেকশন অ্যাক্ট। আজ থেকে প্রবাবলি 98-এর জাজমেন্ট কি 99-এর জাজমেন্ট। অ্যাপারেন্টলি কনজিউমার প্রোটেকশন অ্যাক্ট খুললে দেখা যায় মেডিকেল সার্ভিসের ডেফিনেশনের মধ্যে কোথাও লেখা নেই। বাট this particular judgment of VP Santha had included medical service within the catena of this CPE Act prior to 2019 under the 1986 Act, and now under the 2019 Act, which has now been very much affirmed by the Honorable Supreme Court. So to cut it short again, there is no need of any confusion whether medical service is included or not. Medical service is included. End this controversy. Know it very well that we are very much under the purview of that Act. So any suit, any proceeding filed under the Consumer Protection Act 2019 by any complainant will lie against us primarily. There is no doubt about it. Now, the very next thing, as I felt, was, as I've been interacting with doctors for the last 20 years, apart from my civil practice, there have been questions common questions. How do we prevent? How do we stop this? There is no definite way to stop it, but you can take care of certain things. I am more worried about my elderly medical practitioner clients, because I remember many people who had started prior to the promulgation and effectuation of the Consumer Protection Act 1986, and they have been happily practicing, merrily practicing well, taking care of patients. But obviously with the coming of this effect of this act in 1986 first, and now with this 2019 Act, and with the decisions changing and other parallel bodies coming into force to adjudicate matters relating to medical negligence, things have become difficult. Now this elderly tier of my clients have been really perplexed. So, and I really am concerned about them. Why am I concerned about them? I've come across many gynecologists, many physicians, many surgeons who have always come to me and said, আমি এত চেষ্টা করলাম, এতটা করলাম, সবভাবে চেষ্টা করলাম, এতদিনের পরিচয় জানো আমার সাথে পেশেন্টের, তা সত্ত্বেও আমার সাথে কথা বলে গেল, যখনই পেরেছি কথা বলেছি, কিন্তু গিয়ে একটা কমপ্লেন করে দিল। Well, filing a complaint is not for any one of us to prevent. The only thing that is left for us to prevent is to see and take care of the papers, which is your BHT. That is the only thing in every conference that I go and I'm asked, I try to answer with this particular answer only. If you take care of your BHT, you are safe. Your case is handled, your matter is sorted at least. By God's grace, till now, Indian judiciary has not really prosecuted doctors too much. The percentage still lies to hardly 1%. Compensations also are to that extent only if we take the real-time data. So there is nothing really that courts are up there always to vindicate anything against the medical practitioners. It is not that. But at the same time, within the room, I would also like to state or apprise my medical practitioners who have come here that with multifarious bodies coming into play, adjudicating bodies, we know the Clinical Establishment Regulatory Commission has come into play. The Consumer Protection Act is there. And over and above, we have our beloved Shastra Bhavan and, of course, the local PS. The Supreme Court in its judgments have stated that you cannot directly go for a prosecution against a doctor. So that is one safeguard we have. Anything happens, you receive a complaint. If it is a local PS, you shall have to forward it after collecting the records to Shastra Bhavan or to a government hospital. If the body there adjudicates that yes, there is prima facie something to take note of, to take cognizance of, then only they shall take up. Usually we come across two types of complaint cases, one which are too grievous in nature or one across gross negligence. Those only will come under the provisions of criminal law or penal statutes. The rest will be governed by either the Consumer Forum, the CP Act 2019, or otherwise Regulatory Commission. The Regulatory Commission has no authority to adjudicate against doctors. It is only for the purpose of adjudicating deficiencies or derelictions against institutions. But, well, the person adjudicating somewhere has been made to issue orders in a manner কি কিছু দিতে হবে, তোমার কাছে যখনই আসবে তুমি কিছু দিয়ে দেবে। তো রাইট নাও যিনি আমাদের অ্যাডজুডিকেট করছেন, আমি আর নামটা নিলাম না, আমাদের কাছেও খবর, আপনাদের কাছেও অনেকের কাছে খবর যে এসেছে যখন কিছু দিয়ে দাও আর কি। এটা অ্যাবসার্ড, আনফর্চুনেট। যে কোনো প্রপার জুডিশিয়াল বা কোয়াসি জুডিশিয়াল বডি তার উচিত এভিডেন্স নেবে, অ্যাডজুডিকেট করবে, will hear out both the parties and then only will come to a conclusion. That very thing is not being actually carried on in this regulatory commission, in my humble view, as I have seen appearing numerous times. On some other hand, they are also preventing lawyers to come and parties being represented by lawyers. এতে আমাদের কোনো দুঃখ নেই, কারণ ওখানে যে কটা মামলা আসে দ্যাট ইজ নট দ্যাট মাচ। কিন্তু কি হয়, নিজেরা যখন ডাক্তারবাবুরা যাচ্ছেন বা হসপিটালও যাচ্ছে, কথাটা ভালো করে গুছিয়ে বলে ওঠা যাচ্ছে না, ইটস নট বিং প্রপারলি বিং এক্সপ্রেসড। তার আলটিমেট রেজাল্ট হচ্ছে যে জাস্টিস এক্স বা ওয়াই যারা থাকছেন বোর্ডে বা অন্যান্য যারা থাকছেন, তাদের প্রায় লিমিটেডই রোল, উনি আছেন আর ওনার কয়েকজন, একটা কিছুটা ওই খাপ পঞ্চায়েতের মতো রুলিং হয়ে যাচ্ছে আর কি, সবগুলোতে না হলেও বেশ কিছুতে। তো এটা আমরা আমাদের লিগ্যাল ফোরামের থ্রু দিয়ে বলেছি, কিন্তু কিছুটা তো সবাই আমরা বুঝতে পারি যে এটা পপুলিস্ট মুভ আর কি, সুতরাং ওইভাবেই চেষ্টা করছেন ওনারা অ্যাডজুডিকেট করতে। সো ফার অ্যাজ হসপিটালস আর কনসার্ন, ডেফিনেটলি দে ক্যান কাম আপ টু if they have anything to state, but ultimately then too they shall have to adjudicate. ওই এর কথা শুনলাম ওর কথা শুনলাম না, আমি কিছু মনে চান্স দেবো না আপনাকে, আপনি বলে ফেলুন। আর হসপিটালদেরও দেখছি যে ওই অল্প বয়সী ছেলে মেয়েদেরকে বলে দিচ্ছে বসে যাও, বা যার লিগ্যাল কোনো নলেজ নেই কিছু নেই তাকে বসিয়ে দিচ্ছে, বলে সে গুছিয়ে বলে উঠতে পারছে না, অ্যাক্টটাও পুরোটা পড়েনি, পরে কমিউনিকেশন প্রেজেন্টেশনটা ঠিক মতো হচ্ছে না, টু দ্য পয়েন্ট। At least the person on the other side knows law. So তাকে বলতে গেলে তো অন্তত somebody must come prepared. So coming back to my issues once again, I have found primarily the latches which have involved a particular patient record into a case of medical negligence. One is the consent. Now this consent or informed consent, as we all know, the Supreme Court states the doctor is supposed to take it. The doctor obviously doesn't have time. The senior consultant obviously doesn't have time. The junior consultant at times takes it casually, fills it up, or maybe the nursing staff makes them sign on a dotted line, And ultimately the result is either some part of the consent remains unfilled, some date is not being put, it remains undated. Any consent form requires witnesses to get into it. There are no witnesses. Contraindications or involved risks, which are an obvious part of it, they too remain not properly written. And it ends up in a problem. Why the problem? Supreme Court says even if you are not negligent, even if the treatment is not found to be negligent, then too, if it is found that you didn't take a proper informed consent, you shall have to compensate if the issue is raised. There's an old case of Samira Kohli versus some Dr. Manchanda. It's a very old case. That particular case is the one which defines consent in particularly medical legal cases. It's a very old concept whereby the lady was probably having a fibrous tumor. The doctor concerned was supposed to get rid of the tumor, and in course of the operation in the OT, he felt that there is necessity to get rid of the uterus and the ovaries all out together. So there was a necessity of ovariohysterectomy. And obviously thinking good for the patient, he had done that, he had removed everything. At that time, the doctor concerned, Dr. Manchanda, that's what the Supreme Court judgment I remember, had taken consent from the mother of that lady, and then she subsequently came up and there was a case, and that from which the consent, the informed consent has even been made firmer, been made more compulsory, and without consent, things will be troublesome. There is no blanket consent, remember it, the Supreme Court has stated it in numerous decisions. Procedures will have to be individually taken care of, consents have to be taken separately. You cannot, at the time of introduction or the induction of the patient in the hospital, take a blanket consent. In many hospitals, particularly the middle order ones, where the nurse just opened up the consent forms and puts in key, এখানে সই করে দিন 1 2 3 4 5 6 থেরাপিও রয়েছে তার মধ্যে, রেডিওলজিও রয়েছে তার মধ্যে, তো ওটা হবে না। যার যেটা কনসেন্ট সেটা সেই সময় নিতে পারলে ভালো, না নিলেও অ্যাটলিস্ট এক্সপ্লেন করে বলতে হবে। Supreme Court says primarily if the patient is conscious enough, তাহলে consent has to be given by him only or her only, not by his relatives. Relatives তখনই দেবে যখন he is not in a position or a capacity to give the consent. Either his sensorium is not proper or is not in a position to exercise due control of his intelligence or intelligent quotient. So, as I've stated that take care of the informed consent. This is something which is very important, and the hospital will of course be prosecuted for this. The doctor will equally have enough trouble for this because he will be doing the procedure, he will be into the entirety of the things, and who is supposed to explain consent? The doctor only, not the nurse or not anybody else. Now the third thing which was taken that way was very, very cardinal, very fundamental, yet very relevant. So love and take care of your bedhead ticket. That is the only friend in your fight. So remember it. Doctors, they come, they treat in the hospitals, they go out, then things happen. I have seen numerous hospitals where the police has seized the BHT, the doctor doesn't know it. The patient party has taken away the BHT, the doctor doesn't know it. So the moment you start feeling that this particular BHT might just land you up in some sort of trouble, kindly at your own behest be in touch with the hospital authorities, because hospital authorities or whosoever in charge might not just contact you. They might be in their own flow, might be in their own mood. And after the BHT has been taken, I have seen many of my clients coming and saying, BHT তো দিয়ে দিয়েছে, আমার তো দেখারও কোনো উপায় নেই, আর দেখে আমি কি করব। খুব কমন কথা। তো সেই জন্যে নিজেরা একটু খেয়াল রাখা দরকার। আমি নিজে মামলা করছি এরকম, যেখানে BHT আগে চলে গেছে, ডাক্তারবাবু জানতে পারেননি, অটোমেটিক্যালি অসুবিধা হয়, মনে রাখা ফ্লো অনেক সিগনেচার বাকি থেকে গেছে কোথাও, ডেট টাইম বাকি থেকে গেছে. So these are the problems which has always been there. And I would request, whenever you are feeling that this BHT might get seized, talk to the hospital, sit with the BHT, go through it from page 1 till the last. Also, sit with your nursing super. Don't exclude that person, male or female. I have had a peculiar experience in a particular matter whereby there was a fall, suicidal fall by the patient party. And the patient died ultimately. And a case was taken up. Ultimately, when the matter came up from argument, I was representing a hospital, a corporate hospital. So I was very detailed and illustrious. I got hold of Canadian judgments, international judgments, local judgments, that suicidal ideation is not something which can be predicted. The patient came with a history of diabetes mellitus. He was treated. Yes, he had a little bit of pedal edema, nothing more than that. He was screened, evaluated. He might have been into depression, but that was obviously not to such an extent which could have given any form of indication to the doctor to refer to a psychiatrist at the very first rate of inception. He was there talking to people, talking to his patient party, his family members. Then suddenly, I remember there was a day, 30th of April, and probably the patient's sons had come and seen him. What they had within the ward, nobody knows. That very evening, the person who was the physician had referred for a psychiatric consultation, stating that patient is a bit drowsy, patient is sleepy, that's all. Nothing more than that. So was referred to psychiatrist. The next morning, the psychiatrist was not available or on call on that very day. And that very night at 4 a.m., the patient jumped off the second floor or third floor of the hospital. Obviously, doctors had nothing to do. Doctors didn't get into any trouble, though obviously they are litigated and they had to pursue it till the end of the litigation. Ultimately, in appeal, we could get rid of no compensation against the doctor, but the hospital was ultimately prosecuted. What I want to share is, in that particular case, I had shown the BHT explicitly. I had argued, I had put in literature, I did everything, but ultimately I was given a compensation for the hospital for 4 or 5 lakhs of rupees. What was the deduction? Kindly appreciate the funny part of the thing. The patient party, the nursing notes was ultimately looked into. Obviously, it is my way to submit the whole BHT. And it is quite relevant because if you don't file the BHT, whether representing hospital or hospital, of course, you shall have to file the BHT. Even in case of doctors also, if you need to substantiate any particular point, then you have to file the BHT as annexure to your reply or as annexure to your evidence. So after going through everything, suddenly the other side pointed out that in the nursing notes, where we state or we find those columns, psychological counseling or emotional quotient, intake, outflow, there is this point of psychological, I don't exactly remember the heading, there's long lines like graphical structures, and we all know that nurses usually go on putting ticks randomly, one after another. They hardly go into it, look into it. Just only put in, fever, everything is there. So, febrile or not. So, there was this tick on almost every column, and there was this tick on every day on the emotional quotient. The judge, in the judgment, interpreted that I find tick marks in the column emotional quotient. This emotional quotient tick mark means that the patient was emotionally very bad. He had an emotional quotient. Number one. What is the other funny thing? The BHT, the other side showed that the side grills or the side rails were there on the bed. And the patient, obviously at the time of sleeping, we all know that the side rails are put up so that the beds which are not very wide, the patient might just fall down. So the judge interpreted that, yes, so side rails are there, it means that the patient must have been emotionally vulnerable. He was probably looking for a chance to escape or would have escaped. They should have posted security. They didn't post security. And it is putting up of side rails, and this emotional quotient makes me conclude that he was emotionally vulnerable from the very first days or primary days of treatment. And adequate care was not taken of. Hence, there has been substantial negligence on the part of the hospital and the doctors. So they compensated. Probably first of time at the lower court it was 15 lakhs. We went for an appeal. Ultimately the doctors' names were taken off from the compensation. The hospital was made to pay 3 lakhs. So this is the category of deduction that the judge of your state and of your country can make. So this one has to remember. So we have to be very explicit, very clear in our BHTs, in our writings. There is a Punjab judgment in the Consumer Courts of Punjab, whereby illegible handwriting of doctors, for which a doctor had been made to compensate for 50,000 rupees. It's a 2-3 year earlier judgment. So these things have to be taken care of. Either you take it care yourself, or you tell your juniors who are under you to take care of those, not to take it lightly. The BHT can save you, no matter to what extent your treatment or your other things come up. Of course, unless there is something really wrong into it. So take care of your BHT, that is your only friend. The dates, the chronology of events. Recently I am advising my clients to write down in Bengali on the left hand side and to make the patient party sign, signature, and everything should be there. The knowledge of giving consent must be there in the patient party. This is something which is very important. That should be taken care of, because no matter how much we take it, if the patient party, who are always prone to saying that আমি কিছু বুঝিনি ডাক্তারবাবু যা বলেছেন তাই নিয়ে নিয়েছি, হাসপাতাল থেকে যা বলেছে তাই করে নিয়েছি, at least যদি তার regional language, if his regional language is used, সমস্ত হাসপাতালেই আমরা প্রায় এখন 3টে ল্যাঙ্গুয়েজ করে দিয়েছি, made it in 3 languages, English, Bengali and Hindi. At least these 3 we have already made. So and of course contraindications সেগুলো লিখে থাকা দরকার। এর পরে করলে পরে at least there should be enough content in our hand to show that yes, we had made efforts to explain. That is something very important. As I slowly move further ahead and probably into the last part of my rendition here whatsoever, coming before this conference, one more thing I need to tell you that is very important for you to know. The pecuniary jurisdiction of Consumer Forum has been revised very recently, 4 months back. And it is previously, after the coming into effect of the 2019 Act, it was from 0 to 1 crore was district commission. District commission means all district forums in every district, whatsoever, how many consumer forums are there, depending on territorial jurisdiction. যে থানার ভাগ করা আলাদা jurisdiction আছে, যেখানে cause of action হয়েছে সেটা দিয়ে কনজিউমার ফোরামের মামলা jurisdiction হয়, অর্থাৎ হাসপাতাল যেখানে, ক্লিনিক যেখানে, সেইটা দিয়ে jurisdiction হবে. The particular matter will go to that concerned consumer forum court. So after coming into effect of the 2019 Act, 2019 অ্যাক্টের পরে প্রথমে ওরা পিকুনিয়ারি লিমিট করেছিল 1 কোটি টাকা অবধি, আপ টু 1 crore ডিস্ট্রিক্ট কমিশন, 1 crore to 10 crore স্টেট কমিশন, মির্জা গালিব স্ট্রিটে আছে একটাই স্টেট অ্যাপেলেট কমিশন, মোর দেন 10 crore দিল্লি বা ন্যাশনাল কমিশন. They have changed it 4 to 5 months back. It has been changed to 0 to 50 lakhs district commission, 50 lakhs to 2 crore state commission, above 2 crore দিল্লি. মেডিকেল ইমডেমনিটি আপনাদের সবার আছে, থাকা না থাকা সেগুলো সবই আলটিমেটলি কি হচ্ছে তার উপর. আর একটা কথা শুধু মনে রাখবেন যে উকিলবাবুই মামলা করুক, সেই উকিল অ্যাডভোকেট মামলা বুঝছে কিনা, দিস ইজ ভেরি ইম্পর্টেন্ট. সো গেটিং ইন টাচ উইথ ইউর লয়ার পার্সোনালি, in my mind, in my evaluation is very important. That has helped. I have seen medical legal cases being fought in this state casually, very casually. And the people who have been representing have no basic iota knowledge of physiology. They are running organizations, they are representing, they are providing indemnities, but they are engaging advocates who are below par category of understanding the very subject itself. At least some educated person capable of understanding this hyper-technical discipline must be represented you. Be aware of that. Don't think that nowadays many banks also, everybody is trying to give some indemnity and obviously trying to get in touch with some legal firm giving us support. But my advice to you would be, do get in touch with your lawyer. Brief him personally, see whether he actually understands. The first thing that comes to be taken care of is the reply. As soon as a summons comes in with the complaint, you need to give a reply within 45 days maximum. From the date of receipt of the summons, your reply must come to the court within 45 days. That is called the written version. You have one chance to give the written version. So the written version, according to me, should be drafted, taken care of with maximum care. If your written version, which is your pleading, is not taken care of, is not adequate enough, you cannot take that plea subsequently in your evidence. And if you cannot take it or bring it in the form of an evidence, and if it is argued by the other side or the complainant that yes, this matter was not there in the pleadings, then be sure that point will not be urged before the forum or the court, or court কিন্তু সেই পয়েন্টটা দেখবে না, দেখতে পারে না। এটা আমাদের আইনের বেসিক ভাষা। যা প্লিডিংয়ে নেই তা এভিডেন্সে দেখতে পারবো না, যা এভিডেন্সে নেই সেটা কিন্তু জজের সামনে নেই, ইট ইজ নট বিফোর দ্য কোর্ট। তাহলে আমি অনেক কাগজ ছিল, অনেক কিছু বলার ছিল, অনেক কিছু বলেছি, আমি উকিলবাবুকে বলেছি, আই হ্যাভ টোল্ড দ্য লয়ার, আই ব্রিফড মাই লয়ার, আই হ্যাভ টোল্ড হিম, but he couldn't place it, or he didn't place it, or I couldn't really take care of whether the pleadings are there or not. Tale ultimately it will not go in my favor or to my aid. That is there. After pleadings, what does come in medical legal cases nowadays? The trend is to go for an expert evidence. Now that is for the complainant to primarily go for an expert evidence. If the expert evidence comes, it usually takes 2 to 3 years. You get enough time here. Either it goes to SSKM or it goes to National or Medical College or wherever. Minimum time 2-3 বছর লেগে যাবে, expert evidence আসবে. In the meanwhile, I advise my clients to take a parallel expert evidence also. Private institutions হলেও হতে পারে, গভর্নমেন্ট হলে বেস্ট। কোনো গভর্নমেন্ট ইনস্টিটিউশনের কোনো ডাক্তার, কোনো রিটায়ার্ড colleague of the same discipline, সব থেকে ভালো। After the expert evidence comes in, then it's a point of questionnaire, evidence by either parties and then questionnaire. Now what is evidence? Evidence is the very same narration of the pleadings which you have stated in your written version. যা pleadings এ লিখেছিলেন, যা written version এ লিখেছিলেন, the very same thing, repetition, is in the evidence. Evidence we need to put in our documents, not literature, mind it. We need to put in our documents like BHT, documents like our prescription. I've advised many clients to, obviously nowadays most are keeping scanners within their own personal chambers. Corporate hospitals are obviously keeping it. ওই আউটডোরের প্রেসক্রিপশনও যেন একটা কপি থাকে, তাহলে অ্যাটলিস্ট কী বলা হলো না হলো, কি আমি অ্যাডভাইস করেছিলাম তার রেকর্ড থাকে, নাহলে পরে স্ক্যান করা না থাকলে বোঝা যায় না, রিপ্লাই দেওয়ার সময় অসুবিধা হয়। And the other thing that is very important is after evidence, then finally as it proceeds towards argument, that is the brief notes of arguments or BNA. The brief notes of arguments is based on the evidence submitted by both the parties, written questionnaire if any made by any parties. যে পক্ষ এভিডেন্স দিচ্ছে, দুপক্ষরই এভিডেন্স there, both the sides have the right to give evidence, the doctor, the hospital and the complainant. the other side has a right to cross-examine. এই কনজিউমার ফোরামে অরিজিনালি আমরা যখন 1999 2000 মামলা করতাম বা 2001-2তে, তখন অন ডক হতো, এখন অন ডক হয় না, এখন ইন রাইটিং হয়। এই ইন্টারোগেটরিজ নিজেকে করতে হবে, ড্রাফট করে লয়ারকে দিতে হবে, তার উত্তর দেবে, আমাদেরকে করবে, আমাদের উত্তর দিতে হবে। বেসড অন দ্যাট ফাইনালি ব্রিফ নোটস অফ আর্গুমেন্টস তৈরি হবে। ব্রিফ নোটস অফ আর্গুমেন্টসের বেসিসে ফাইনালি দ্য ম্যাটার উইল বি অ্যাডজুডিকেটেড। This is the entire process which I have stated, how a consumer protection matter will go through. Any matter, civil matter, whether under the CP Act, whether it is a civil case, will follow this pattern. This is the basic pattern. একটাই কথা বলে I would like to end. I came across a judgment 2-3 days back of the Honorable Supreme Court, যেখানে the doctors have been acquitted, the doctors have been relieved of the charge, and there was a point whereby the party has brought in an expert evidence. The Honorable National Commission gave a judgment against the doctors, against the hospital, and as a compensation of 17 lakhs was awarded. The Supreme Court set aside the judgment, released everyone, and stated that if any expert evidence is given by any individual party complainant, it is to be seen that it comes with a formal legal sanction in a proper manner, not just taking someone's opinion and putting it before the court will not give a sacrosanctity to that particular expert evidence. So under section 45 the Supreme Court ruled against, and the doctors and the hospital was saved. So this is a recent judgment, because in many cases we find expert evidence coming in, and this judgment obviously will come to our aid. It's a very 2021 judgment. So considering all these things, I hope I have been able to give a brief outline. Obviously conferences like these or lectures or symposiums like these can't really go more deep than this. So I've been able to brief you that we are there within the ambit of Consumer Protection Act. A notice comes in, you approach your lawyer, you get a reply ready, you get your evidence ready, and finally the arguments. In the meanwhile, you have a right to give an expert evidence, they have a right to give an expert evidence. Contact your lawyer personally, sit with him, make him understand your subject. Medical legal is a hyper-technical discipline. Don't leave it for the lawyer to understand. That's it. Please.
But at least I know few of my friends has gone through. See, there are like organizations what you are telling, and the experience with those organizations is horrible. Like in every instances, basically the lawyer and the situations become worse, and they had to put their personal lawyer. Now you tell me, like we have our indemnity insurance, we don't know what should be the limit for us. Second thing is, like if this is like not useful, then what we should do?
Let us be a bit candid in this question to help you guys. When originally this indemnity thing started in Kolkata, there was one organization, I am not intentionally naming the organization. Then it broke down, it has now almost gone into atrophy. The other one came up with few people coming out of them, and now they are running the maximum. A few more banks have joined in. The amount of insurance depends usually on the nature of the service the doctor is giving. Say for example, I suggest surgeons to be on a higher side. There is no limit, there is no yardstick, there is no thumb rule. Somebody tells I have taken 1 CR, somebody tells I have taken 2 CR. It is okay. There is nothing to guide you through that, because case can be filed of any amount. You can't really go into that. Now, so far as the representation is concerned, one can represent through his or her own counsel, can take an insurance individually, need not take advocate from those organizations, can represent, shall have to keep the bills. I have seen quite a few doctors who are nowadays have been quite jittery with these organizations, and they have renounced their membership, and now they are taking up individual insurances engaging their family friends as lawyers or family lawyers or known people or people coming across, and they're fighting it. You need to place in the bills of the lawyers, keep an online trail of the payments that you're making to the lawyer and submit those. And of course, if you have a chance to take an insurance now, even now, then obviously go through the terms and see that, see, I won't be engaging from anyone. I'll be directly a national insurance guy or ICICI Prudential or XYZ whatsoever. Comes you, yes, what is important is the person who is selling the insurance to you, he or she must disclose, must know what is there in the clause, and so should you. How, to what extent they are offering. Because I have, as these organizations I know, in criminal matters sometimes they are tied up with Reliance. So in some cases they have given, some cases they have not given, in criminal matters. So that chance remains, that is always there. And frankly speaking, if you are supposed to engage someone with whom, a lawyer with whom you are supposed to know directly, one-to-one, it is better to engage him personally, pay him personally, keep his bill, submit for reimbursement and get it paid back. That has been an easier trip. I have seen. You can talk to your lawyer at the dead of the night. This reply was not properly drafted. Isme kuch, there's something wrong in it. Do you have a chance to amend it? At least the person concerned has a direct contact with you. He knows, yes, this doctor is my client. He's paying me. He's working with me. I've known the subject from him, and this is how we argue. And one more thing I have felt, this I have learned from two of my very senior doctor clients. They personally go on the date of the argument, final arguments. They remain present. Because you do not really know what a lawyer is ultimately going to state before the court or the forum on that very day. To what extent, whether he will be having 5 matters, 6 matters, where from he will be coming, whether he will be at all in a position to argue, what is the mindset of the judge. Too many things are important. So, final arguments, I have seen it from one of my 2 clients who have told me, okay, Atish, we are going. You argue, I'll be sitting just beside you. Any assistance, I'll be there. It also reassures the advocate also. That is what I have felt to handle in a manner. Oh, sir, please.
Mr. Majumdar,
Yes.
to recognize me, and I'm grateful. And
Do you remember Dr. Majumdar? Dr. M.K. Majumdar, you had done TURP in South Calcutta.
um,
And I was pretty young, and whenever everything used to be done, you used to sit with me and used to together.
During my this 39 years of urological practice in Calcutta, after returning from England 1983, because there we have to be member of this what is called BUPA, remains legally. So we and my wife we took that insurance indemnity since then. So during this my 39 years, I faced 2 cases. That was, initially there was no this crisis, just even with few investigation, you can require, I know what is the disease, I know what to treat it, why to spend so much of money? So I have done that. But in 1994, one doctor, he's in government of CGHS, he came to me with for prostate operation. He said, I'm going to Bhubaneswar, the conference. After coming back, I'll do the ear operation. So I did on the 1st or 2nd of January, 1995, I think 93, and it was okay. He did not come for follow-up. After 1 month, suddenly rang up, doctor, I have found the biopsy report. It was with my wife was carrying, and I see there is cancer. So he said, I'm coming. So at that time, there was no that sort of prostate option, this orchidectomy. So I explained that orchidectomy, and you need this orchidectomy operation. So that as soon as you can do it, because I have to join my duty. So I did that with the consent of his wife also for orchidectomy. Then suddenly it was in the newspaper, that one doctor that in Jugantar, that one doctor has complained against another doctor. It was a hue and cry. And then my friend, just he was in our same building, Ashok Rai, he said, Dada, have you done any operation like that? Then I found out, yes, but yes, he has complained. Well, you send me this Okalat Nama, I'll find out what is their complaint, because complaint will come by post. So we went through that complaint, that he said that probably he sent the slide for review without my permission. Okay. He said that, and that showed no malignancy. So he said, you have done orchidectomy, it is affecting my and my wife's sex life, I am physically disabled, and you have to compensate me 10 lakhs. So because of 10 lakhs, the insurance company said, ordinary, your lawyer will not, we have to depute one barrister, a barrister. But I told him, your barrister will be there, but my lawyer also will be there. So Mr. Prabir Basu, I don't know whether you know him, he said, this is my first case, Prabir Basu. Later on, I think he is doing more this consumer things. And anyway, we said the operation was done on the basis of histopathology, so there was no negligence. Number two, there was no evidence we have taken the operation was done complementary. And that the judge also said there is no evidence, he could not show any evidence that he has given the money, because he has not mentioned how much money he has paid to the doctor. It is difficult to believe. And second, he has done on the basis of pathology, so there was no negligence. Why he has not involved the pathology during this time?
That means you could sustain on the basis of your literature, on your discipline.
It took 6 years. So that is a bit mental.
This must have been in which year? Quite early, I believe.
1996,
1994.
94. Judgment
Because
came
Probidha nowadays almost has given up practice. So
2000. That's why be careful about these things. And also now they are saying why so many costly investigation. I tell the patient that look, in those days I have done operation with minimum investigation, but I can't do now because of this CPA.
And if it is medically warranted,
that I told them, it is not their fault, the doctor's fault, because the CPA has forced them to do all these tests to safeguard their practice.
Thank you. Thank you, everyone.
Thank you, Mr. Majumdar. That was an exceptional talk. Now we shall be proceeding to Falak, and this marks the end of this program today. Thank you, everyone. I request everyone to check out from their rooms, call 0, ask for a Toto, proceed to the reception. After checking out from the reception, please proceed to Falak.